The world that they offer you is gray and promises dystopian control. They offer you safety and security purchased with the currency of your freedoms. But on this channel, we say absolutely not. The warmth and freedom of individual liberty will pass on from us to the next generation, and it starts right now. Welcome back, brothers and sisters. I am Braden. This is Langley Outdoors, the place where we not only talk about what's going on in the gun world, our beautiful country, how we're going to fix this bad boy together. Guys, what would you do is if in the middle of the cage fight between Elon Musk and Donald Trump on X today, we actually got a 28-state coalition that says, Maine, back the F off on waiting periods, along with the NRA and the NSSF. Guys, something's happening under the surface. All the clouds are gathering over a problem in Maine, and I think we're going to see some more action pretty quickly. Everything I've got for you is linked in the description box below. This is a pretty big one, guys, so make sure you send this out, you hit that like button, subscribe to the channel, turn the notification bell on, and make sure that YouTube is not interrupting your subscription for freedom, and thank you in advance for doing just that. All linked sources are in the description. I always bring receipts. And don't forget, guys, to get your We're Coming for Our Rights limited time design t-shirt. Available in navy and in black, men and women's. There's a link in the description box below. Wear what you believe, because we are pissed. We're coming for our rights. Mexico just found out the hard way, along with Braden and all their ilk, and we are going to continue coming for our rights until we have them fully restored. Wear what you believe. There's a link in the description box below. You support the channel when you do it, and thank you in advance for all of you guys who are looking at that and who have already jumped on board. All right, that is the wrong button. Let me hit the right button. Here we go. So we're going to jump over my X profile, where we're doing a lot of things around spreading information very quickly, and that's where we came across this. At Braden LOA, make sure you follow me over there. This is Larry Keane. Now, why is Larry Keane important? This is the guy who is the SVP for NSSF, the National Shooting Sports Foundation. He's also, coincidentally, the guy who got the PLCAA through Congress and became law, which is the very thing that stopped the Mexico lawsuit today. So that's who this guy is. Attorney General Knudsen leads a 28-state coalition against unconstitutional waiting period laws in Maine. Now, I'm going to show you a few of the things that from this actual release from the actual Attorney General of, I believe it's Wyoming, Montana. What did I just say? Why can't it words? Didn't say it. Oh, that's why. Attorney General Knudsen from Montana. There we go. So what we're dealing with right now is that same thing that I tell you guys with the left. You know, when they all gather over one little area and they all kind of coalesce and then it starts falling straight down on that one little topic. That's what's happening right here, but on our side. Look at this. This is from Attorney General Knudsen. Let me zoom in for you guys so I can actually show you. 28-state coalition against unconstitutional waiting periods law. Now, this is coming from Maine, and as you can see, the releases today. Attorney General Knudsen leads 28-state coalition against unconstitutional waiting periods. The amicus brief filed in the case Beckwith versus Frey, you're going to hear that name a lot, I'm betting, asked the U.S. Court of Appeals for the First Circuit Court to affirm the district court's decision halting Maine's waiting period law that went into effect in 2024. The district court properly found that the right to acquire firearms is covered by the Second Amendment's plain text, and that Maine's proposed historical analogs, licensing and intoxication laws, flunked Bruin's inquiry. So basically, translation, you're wrong. The Bruin decision still stands. You can't make people wait 72 hours just because you want to. It's their constitutional rights. We'll see you in court. We're filing on the side of freedom. That's the translation there. But let's continue. I got the whole document and everything for you. The U.S. Supreme Court made clear in its ruling, New York State versus Bruin, that courts must determine whether the Second Amendment's plain text and historical understanding cover an individual's conduct. In the brief, Attorney General Knudsen argues that Maine's waiting period law fails Bruin's inquiry because Maine failed to produce any evidence of historical waiting period laws during the country's founding or Reconstruction era. Now, why do I love this? Because it literally goes straight to the Bruin Declaration, a decision. It doesn't go after the Administrative Procedures Act, doesn't go in a circumventing, I don't like the way they did it. It literally goes after Bruin. And that is what we need. We need a lot more you're violating Bruin versus you did it wrong. That's a very important piece. Now, Maine has countered that the court should take a more nuanced approach to viewing its waiting period law due to unprecedented societal concerns involving dramatic technical changes. Get out of here. It argues that the waiting period law addresses a problem that did not exist at the founding. Quote, the impulsive use of firearms to commit homicides and suicides, but human impulsivity is not a new societal problem, and Maine fails to point to any rapid advancement in gun technology that warrant Bruin's more nuanced approach. Now, the reason that I read that, their argument is literally people are impulsive, so we can make them wait 3 days. The Bruin decision doesn't say you can infringe their rights if they wait 3 days because they're impulsive. Impulsivity is not a new problem, like they state there. I like this a whole lot of where this is going. Now, here's a quote from it, and then I'll show you some other things that are important. Maine failed to carry its burden to show that its waiting period law is part of the historical tradition that delimits the outer bounds of the right to keep and bear arms, Attorney General Knudsen wrote. The district court found that Beckwith was likely to succeed on the merits of her Second Amendment claim because the waiting period law, quote, employs no standard at all to justify disarming individuals. And I'll read all the states here in a second, but let me show you something else because this is important. In the conclusion, which I'm going to read to you in a second, they're basically saying the same things I just showed you, except for a few little key points. NRA is jumping behind this. They've also filed an amicus brief. Then you go over to NRA, who just did the announcement today for that amicus brief. Guys, everything is piling over to see, like basically over that target. When you see all the clouds over a certain area and topic orienting at the exact same day and the same things are dropping, you are seeing things happen. You're reading what they're forecasting, what they're planning, because it's very obvious. They do this on the left and they do this on the right. That's why we talk about these things on this channel. But here's the conclusion, and I'll read the states. Bruin explained that when it comes to interpreting the Constitution, not all history is created equal. Constitutional rights are enshrined with the scope they were understood to have when the people adopted them. So evidence closer in time to the Second Amendment's adoption is most relevant for understanding the amendment's scope. Evidence of historical regulations through the end of the 19th century could be relevant, but only if it confirms what prior evidence already established. The Second Amendment protects the right to acquire handguns for self-defense, that's from McDonald, with few exceptions. Maine relies on out-of-date historical analogs passed well after Reconstruction. That's important because Bruin is before Reconstruction. Surely too slender a reed on which to hang a historical tradition of burdening the right to acquire firearms. Even if Reconstruction-era statutes and local ordinances could provide probative evidence of the Second Amendment's original meaning, Maine's evidence still fails to identify relevantly similar historical analogs. Sweeping aside Maine's irrelevant evidence leaves little remaining historical support for its waiting period law, even when employing Bruin's more nuanced approach. This court should affirm the district court's order, and that came out yesterday and it was announced today. As you can see, Austin Knudsen, Montana Attorney General, along with these states right here. And I'll leave them on the screen so you can see if it's your state. And that also, actually, a more concise list is right there. You can read it while I wrap this up. So effectively, guys, where we're at in this moment, Maine instituted a 3-day waiting period, a 72-hour waiting period. That was back after the Lewiston shooting. That was part of the whole thing that they did. Now, they're going after the Bruin decision and saying that, well, Bruin allows it because, new technology means people are more impulsive, which is completely stupid. But they're trying to stay inside the Bruin decision, which is not going to work because, again, impulsivity is not new. They don't have a foot to stand on. And you have the 28 attorneys general or 28 states going right over and hovering over the target. The NRA is coming over here hovering over the target. I bet you very quickly you're going to see a lot more gun rights groups hover over this target because when one or two of these individuals go over that target, it's not long until the obvious weakness is exposed and they all pile on. That's what I've got for you guys. Let me know what you think in the comments down below, and I will see you on the next one. I'm Braden. See you later.